Straight ahead on Law&Crime Daily. Mobile mass shooting suspect Ezekiel Kelly appears in court for the first time following a rampage across the city of Memphis, which left 4 dead and several others injured. Plus, dozens of media outlets are fighting back against requests from Doomsday duo mom Lori Vallow Daybell's attorneys as they seek to ban cameras from court. And the murder of Dan Markell.
Mr. Adelson and his family have substantial wealth and the financial means to flee. Mr. Adelson even discussed with Ms. Magbanua his intention to flee in the event he was prosecuted.
The victim's former brother-in-law, Charlie Adelson, is back in court and makes a plea for pretrial release. And later, the disappearance and death of Kristen Smart. Jurors hear key evidence from forensic specialists as father and son Paul and Ruben Flores stand trial in the 1996 murder case. Law&Crime Daily, covering court cases from coast to coast.
Welcome everyone to Law&Crime Daily. I'm your host, Mike Sachs. The man investigators say is responsible for a killing rampage across the city of Memphis stands before a judge for the first time after he allegedly opened fire in a string of deadly shootings, some of which was live streamed on social media. 19-year-old Ezekiel Kelly is being held without bond following a night of deadly shootings in which 4 people were killed and 3 others were shot. The mass mobile shooting began in the early morning hours on Wednesday when Kelly allegedly shot 24-year-old Dwayne Amir Tunstall while the two were with friends at a North Memphis home. Hours later, around 4:30 that afternoon, officers responded to a second shooting where another man was pronounced dead at the scene. Police responded to an AutoZone store where Rodolfo Berger was shot and seriously injured. Police say that shooting was broadcast live on Facebook. Berger remains in serious condition. Kelly then allegedly shot and killed Allison Parker in a carjacking, and just before 9 that night, Corteria Wright was shot and killed. 30 minutes later, Kelly was taken into custody following a high-speed chase with police. He appeared before a judge Friday morning wearing a dark blue jumpsuit and a face mask. He did not enter a plea, and no bond was set, but Kelly was appointed an attorney who indicated she will request a gag order be put in place. The judge also acknowledged the death penalty is possible in this case. Kelly is set to be back in court on Tuesday. Now joining us today are co-host Terry Austin and criminal defense attorney Josh Ritter. Now Josh, after reports of the shootings, the police warned people to shelter in place and suspended bus service. Do you think those were appropriate precautions to stay safe during that uncertain time?
Mike, it's a sad state of affairs of the times that we live in that I can't imagine if any attempt by the government to protect their community would be seen as overreacting, right? When we see these mass shootings occurring at schools and outside of schools, at markets, you would think that they would take any attempt to protect their community. And you got to understand, too, that at the time that they were taking these measures, they didn't know what was really going on. It could have been that there was more than one shooter involved. It could have been a coordinated effort. They didn't know if this was random or if it was targeted. So you can understand why they would make any attempt to kind of protect people, including asking people to shelter at home and avoid public transport. So I don't think it was an overreaction at all, and maybe it saved some lives.
Yeah, and it certainly made people feel a little more safe during a time of chaos around the city. Now, Terry, during a press conference, Memphis Mayor Jim Strickland underscored the importance of the truth in sentencing law in Tennessee. Now, what does that new law say?
Well, that law is something that everyone's talking about right now. It says that anyone charged with violent crimes like a murder or rape or an aggravated assault, they have to serve 100% of their sentences. And there are arguments in favor of that. One thing, it'll keep the violent criminals in jail for as long as possible and maybe cut back on some of the crime. But there are also arguments against the law, and one of it is that it doesn't provide for leniency when you have individuals who've been incarcerated and they've been doing good behavior and they deserve another chance. The argument is that those individuals shouldn't be in jail for the entire term, but only for a percentage of the time. Plus the fact, you have to remember, it costs money to house and to feed and to educate all of these individuals. And if every prisoner were in jail for the entire time, it would be a strain on the system.
Yeah, it's a perpetual tough on crime versus smart on crime. Some people can say is soft on crime. Others say tough on crime is too punitive. It's the constant policy debate we're having in the states and federally as well. Now, switching now to Chicago, where the only defendant testifying in the R. Kelly sex crime case takes the stand for the third day in a row as prosecutors question the R&B star's one-time confidant. 55-year-old Kelly, a convicted sex offender here in New York in a federal court, now stands trial in Illinois on federal sex crimes charges. Now, back in 2008, the singer was acquitted of charges for creating a video of himself having sex with a 14-year-old. At the time, the alleged victim and her family denied their involvement, but 16 years later, the accuser and her mother testified for the prosecution, saying they lied about their involvement after Kelly threatened them. Kelly's former business manager and co-defendant Daryl McDavid has testified now for 3 days straight. He's been asked about Kelly's questionable behavior in the early 2000s and testified that Kelly's legal team told him the sex tape was fake. On Friday, McDavid took the stand once again, this time for cross-examination. Prosecutors say he played a key role in funneling money to women who said they had been sexually abused by the singer. Now, also in celebrity news, Puerto Rican superstar Ricky Martin is suing his nephew after he accused the singer of incest and sexual abuse. Martin accuses Dennis Sanchez Martin of extortion weeks after he withdrew his sexual assault complaint against his uncle. Sanchez claimed he had a romantic relationship with Martin for 7 months and that Martin didn't want it to end. Sanchez also claimed Martin didn't follow him on social media, and then he allegedly published Martin's phone number online. Months later, he filed a sexual assault lawsuit against the former Broadway star and pop singer and asked for a restraining order. In July, the case against Martin was dismissed. Now the singer is claiming the accusations against him have cost him millions of dollars in lost income. The lawsuit says the harassment from Sanchez continued despite Martin's nephew admitting under oath that he had never been sexually assaulted by the artist. Now, still ahead on Law&Crime Daily, requests from defense attorneys for Lori Vallow Daybell to block cameras from court hearings, and they're met with pushback from dozens of media outlets. But first, Charlie Adelson, who's charged in connection to the death of his former brother-in-law Dan Markel, appears in court to argue for pre-trial release. Welcome back. Now, several updates to share in the Doomsday Cult duo case involving Lori Vallow and her husband Chad Daybell, as the couple faces murder charges over the deaths of Vallow's kids and Daybell's former wife. First, a judge has denied a request from Vallow's defense team seeking to send her case back to a grand jury to clarify language in her criminal indictment. The couple are charged with multiple counts of first-degree murder and conspiracy to commit murder in the killings of Vallow's children JJ and Tylee Ryan and Chad's first wife Tammy Daybell. Lori's legal team is also seeking to ban cameras from the case for any upcoming hearings and the trial set for next year. This came after the defense said media abused the privilege to videotape when it zoomed in on Vallow's face during a hearing last month. They argue cameras could be used to zoom in on notes, violating attorney-client confidentiality rules. On Thursday, more than 30 news organizations asked the judge to reject that request. A hearing on that is set for next week. So Terry, is Lori Vallow Daybell's attorney making a valid argument here to ban cameras from the courtroom given what we just saw and heard?
Absolutely not. It's not a valid argument just because the camera zoomed in. Come on, give me a break. The public has a right to view the proceeding. In fact, the attorney representing the media basically said that news organizations, they cover these criminal trials because it's on behalf of the public and they want to ensure the public confidence in the criminal justice system. That was the argument, and I couldn't agree more with that argument. That counsel also noted that there are trained technical staffers in the courtroom. They know not to zoom in on notes. So that was just an argument I think that was meritless. It hasn't happened. It's not going to happen. And I definitely think that in order to make sure that the public has access to this, that you have to have cameras in there. And this particular case, Mike, is really important. It's a case that everybody knows about worldwide, not just in the U.S., and it involves 2 young children. And the public wants to make sure that justice has been served. So definitely the cameras need to be in there. We'll see ultimately what occurs, but I think the argument for the media is the argument that should win.
Yeah, and it's not the media's first rodeo here, as evidenced by the fact that we have a station we're talking about right now, all these issues. We have trials all day long. This is something people know and people watch, and the people there are going to be professional about filming what's there. Now, Josh, Daybell's criminal trial is not expected for months, but hearings are being held to resolve legal issues. What other types of issues can we expect to be argued moving forward?
It's all about evidence. They're all going to be deciding about what is going to be in front of the jury and what should not be in front of the jury. They're creating the landscape of the trial, right? They want to make sure this is more important for people to understand that much of the trial is done before the trial, right? What happens during trial, taking witnesses, all of that should be fairly expected by the attorneys. Rarely do you have those kind of Perry Mason type moments where there's some sort of shocking evidence that comes out. So all of this is arguing about what's going to be in front of the jury and what shouldn't, so that they all understand the landscape.
And again, that's going to begin the trial and all starting next year, but right now these pretrial motions moving forward. Now, meanwhile, an arrest warrant is issued for Kayla Montgomery, the stepmother of Harmony Montgomery, a New Hampshire girl who investigators believe was murdered. Now, Kayla was set to appear in court on Thursday to discuss her charges related to Harmony, but unrelated to the child's disappearance and death. Officials allege Montgomery lied to the New Hampshire Department of Health and Human Services to collect welfare on Harmony's behalf when the girl was not in Kayla's care. Now, the case of missing Harmony Montgomery has gripped New England and the nation for the last year, after the little girl likely disappeared in November or December of 2019. But police didn't know she was missing until nearly 2 years later. Investigators announced last month they believe Harmony was murdered, though her body has never been found. Her case turned from being a missing persons case to a homicide investigation, and Harmony's father, Adam, has also been arrested on related charges. But no one has been charged in direct connection so far to her disappearance. Now, coming up on Law&Crime Daily, accused murderer Charlie Adelson appears in court as he faces charges in the 2014 death of his former brother-in-law, Florida State law professor Dan Markell. Plus, the trial of father and son Paul and Ruben Flores. Jurors hear key testimony for the prosecution in the disappearance and death case of Kristen Smart. Welcome back. A judge rules Charlie Adelson will stay behind bars pending his trial as he faces charges for allegedly orchestrating and paying for the plot to kill his former brother-in-law, Florida State law professor Dan Markell, who was murdered 8 years ago. A judge denied Adelson eligibility for bond at a hearing Friday morning in Florida. Markell had an ugly split from Charlie's sister, Wendy Adelson, before his death as the families fought over custody of the couple's 2 sons. Markell was ambushed in his driveway as he arrived home on July 18, 2014, and investigators have long suspected the Adelson family was involved. It was later determined Adelson's then-lover, Catherine Magbanua, allegedly hired 2 gunmen to attack Markell. One of them previously pleaded guilty in a deal with prosecutors. Sigfredo Garcia was convicted in 2019, while Magbanua was retried and convicted earlier this year after the first jury was deadlocked. Adelson was indicted in April for his alleged involvement. On Friday, Adelson's attorneys argued he should be granted bond until his trial. Prosecutors argued against it.
Charlie Adelson is a classic flight risk. He faces charges of first-degree murder, conspiracy to commit murder, and solicitation to murder, and the very real prospect of spending the rest of his life in prison. After all of these factors, the serious murder and other felony offenses with which Mr. Adelson is charged, the overwhelming weight of the evidence against him, the lengthy prison sentence he faces, and the very real risk that he would flee, the risk that he would corruptly influence trial testimony, and the risk that he would conspire with or be influenced by members of his family, strongly support the denial of Mr. Adelson's motion for pretrial release. Throughout this horror, the Markells continue to fight for complete justice for their son and to be reunited with their grandsons. The interests of the public and of the Markell family as victims of this heinous crime support the denial of Mr. Adelson's motion.
All right, Terry, they're talking about something called an Arthur hearing. What is that and why is it important in this case?
Well, it's critical in this case. In the state of Florida, they have Arthur hearings to determine whether or not someone who's committed a capital offense like murder, whether or not they are eligible for bond. And it requires the defendant to actually show that they are eligible for bond. And there's that procedure that both sides have to abide by. And for the accused to be granted bond, the defense attorney basically has to prove to the judge that there's not enough evidence to support charges and that the defendant does not pose a danger to society and that he's not a flight risk. So really the prosecution has to show it has all the evidence and that the defendant is a flight risk, and the defendant has to argue just the opposite. Many judges generally rule on the side of caution, and they basically say, look, this is a capital offense, it's violent, stay in jail until your trial, and hopefully your trial will come within a speedy time.
Right, Josh, and you're a criminal defense lawyer, and you know that in general, in theory, bail is not about punishment, it's about ensuring someone returns to trial. Now, in this case, based on the facts of what we have here, and they also consider future dangerousness, etc., should Charlie Adelson be released on bond?
No. Despite being a defense lawyer, I got to say no. For the reasons that Terry laid out, right? You're talking about conspiracy to commit murder. You're talking about murder for hire. You're talking about lying in wait. These are all the kind of horrible things that a judge would be concerned with. And you're absolutely right. Judges are risk adverse. And when they hear about this type of a murder, they realize that several people were involved, the planning that went into it, the risk of flight, the evidence against him. I don't think there's any way a judge would, leave their neck out there and take a chance on this type of a defendant.
Yeah, it's really something where no judge wants to, as you said, leave their neck out there, because if something happens, well, that could be on the judge, and people would be blaming that judge as well, and no one wants that. Meanwhile, down in Florida also, the trial for Parkland school shooter is set to begin next week following a week-long break to continue the defense's case. Now, on February 14th, 2018, a then 19-year-old gunman opened fire at Marjorie Stoneman Douglas High School in Parkland, Florida. 17 people were killed and 17 more were injured. In October of late last year, the gunman pleaded guilty to all charges. We still expect to hear from the shooter's brother, Zachary, who is one of the nearly 80 witnesses testifying for the defense. A Broward County jury will decide now whether the shooter receives life in prison or the death penalty. Now, testimony is set to resume on Monday. And when we come back, key witness testimony in the 1996 death case of Kristen Smart, as father and son Paul and Ruben Flores face murder and accessory charges now 26 years later. Welcome back. A Georgia man who was previously convicted of concealing the death of teacher and beauty queen Tara Grinstead will not be granted a new trial. Bo Dukes appealed his March 2019 conviction, arguing the court should not have admitted his confessions and statements to investigators at his trial. The court responded saying they found no error in the trial or sentencing and denied a new trial or a change to his sentence of 25 years. Dukes was charged alongside Ryan Duke in the 2005 death of Grinstead, more than a decade after she went missing. Dukes claimed Duke confessed to him that he had killed Grinstead and dumped her body. The two allegedly burned her body together. Earlier this year, Duke was acquitted of murder and assault charges, but found guilty of concealing a death. He was sentenced to 10 years. Now, both men still face charges in a neighboring county related to burning Grinstead's body. And in California, jurors hear key prosecution testimony from a forensic expert in the California case of Paul and Ruben Flores as they stand trial for the 1996 disappearance and death of Kristen Smart. Smart disappeared after a party 26 years ago. Paul Flores was reportedly the last person seen with her walking her home that May night. Smart was declared legally dead years later, though her body has never been found. Paul and his father Ruben had long been suspected of being involved in her disappearance. Last year, the father and son were arrested. Paul was charged with murder, his father with accessory after the fact, accused of covering up Smart's death and burying her body in his backyard, and later moving the remains. All day Wednesday consisted of testimony from a forensic expert testifying about the property searches done at Ruben's home. She said she helped process evidence collected during those searches, saying there was the possible presence of blood in a cargo trailer on Ruben's property. Jurors also heard from an expert in trace evidence who analyzed fibers found in the dirt behind Ruben's home. She said she identified fibers that were black, brown, blue, and red. Smart reportedly was wearing red and black when she went missing. Court is set to reconvene Monday morning. If convicted, Paul faces 25 years to life in prison. His father faces up to 3 years behind bars. Now, Josh, experts testify that human blood and matching fibers, as we heard, were located in Ruben's property. Is that enough for a conviction for such a long case, that's a long time since the case was last investigated?
Is that enough by itself? No. But it's put together with everything else that the prosecution has put on, I think, yes. You have to remember, for the prosecution, this is a case of a death by 1,000 cuts, no pun intended there. But what they're doing is they're trying to get the jury to ask the question of what are the chances? What are the chances that in the same house where possible blood and fibers were found, that same person had dogs signal to his bed at his dorm room? What are the chances that that same person would be the person that was last seen with Kristen Smart? What are the chances that that same person would be the one who was changing his story about injuries that he had the following day? What are the chances that that same person would have wiretaps where he's having conversations with his mother about possibly, finding holes in a podcast discussing the case? So you put all of that together, and no, one piece of evidence on its own does not stand. It's not a smoking gun, but you add all of these together, and I think you have a case that you can ask a jury beyond a reasonable doubt to return a conviction.
Yeah, Terry, Josh is pretty bullish on this, and Kristen Smart did, in fact, disappear in 1996. So how difficult do you think it'll be for the prosecution to prove this case beyond a reasonable doubt?
Listen, like all cold cases and like all cases without a body, this is going to be very difficult. And obviously, in order to get a conviction, that prosecution is going to have to prove the case beyond a reasonable doubt. If just one juror has doubt, there's not going to be a conviction. And the witnesses on the stand, especially those experts, they're going to be grilled. They already have been grilled on cross-examination about their techniques, about any inconsistencies they may have had in prior testimony. So that's going to give those jurors some doubt. And other witnesses who aren't experts, they're going to be questioned about their memory. There was one witness who had a conversation and she said that his eyes look cold. Well, they're going to be tested on all of that, and that's going to leave some doubt in those jurors' minds. And you have to remember also that the sheer lack of evidence, that's going to present a huge problem. They have these little trace samples of blood and trace samples of fibers, but is that enough? And so I think it's going to be very difficult for that prosecution.
That's right. My amazing co-host Terry Austin and Josh Ritter, criminal defense lawyer. Thank you guys very much for joining us here today. And thank you all watching for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.